The gavel came down hard, and the courtroom went silent.
"Mr. Ellis," Judge Harmon Cole said, leaning back in his leather chair with a thin smile, "I've seen a lot of things in this courtroom, but a man in a thrift store jacket trying to argue contract law is a new one."
A few people in the gallery laughed. Someone in the back didn't even bother to hide it.
The man standing at the defense table didn't flinch. He wore a gray jacket with a frayed cuff, a tie that had been reknotted so many times the fabric had gone soft, and shoes that had clearly been resoled at least once. He looked tired in the way that only single parents look tired, not sleepy, but worn down at the edges, like a stone that had been rained on for years.
"Your Honor," the man said quietly, "I'd like to enter this into evidence."
Enter it," Judge Cole waved a hand. "Just don't expect the court to take your filing too seriously.
This isn't a Wednesday afternoon television drama, Mr. Ellis." More laughter.
The opposing counsel, a sharp young attorney named Priya Deshmukh from one of the biggest firms in the city, allowed herself a small, satisfied smile. Behind her sat her client, a real estate developer named Roland Vance, arms crossed, chin lifted, watching the humiliation of the man across the aisle with open enjoyment. What none of them knew, what none of them could have known, looking at the tired man with the soft-spoken voice, was that in 6 days, the same man would be standing in front of the State Bar Disciplinary Committee, not as a defendant, but as the one filing the complaint.
And Judge Harmon Cole's name would be on the first page. But that was 6 days away.
Right now, all anyone in that courtroom saw was a broke single dad, way out of his depth, about to lose everything.
3 weeks earlier, none of this had even started. Daniel Ellis was the kind of man people forgot the moment he left a room. He was polite. He didn't raise his voice.
He wore the same 3 shirts in rotation and packed his daughter's lunch every morning in his scratched-up plastic container that had survived 4 house moves. His daughter, Maddie, was 8 years old, missing her 2 front teeth, and the reason Daniel got out of bed every single day. Her mother had passed away 3 years earlier, a car accident on a rainy October night, and since then, it had just been the two of them, navigating a life that felt, some days, like walking uphill in the dark. Daniel worked part-time doing paralegal filing for a small firm 2 towns over, the kind of job that paid enough to keep the lights on and not much more. He drove a car with 190,000 miles on it.
He clipped coupons.
He said no thank you more than he said yes when it came to anything that cost money, because every dollar had already been assigned a job in his head before it even arrived. Nobody at Maddie's school knew that Daniel Ellis had once argued in front of the United States Court of Appeals. Nobody knew that for 11 years, before everything changed, he had been one of the most feared litigators in corporate law on the East Coast, the kind of lawyer companies paid 7 figures to keep on retainer, just so he'd never be the one across the table from them. Nobody knew, because Daniel never told anyone. After his wife died, he had walked away from all of it. The firm. The title. The corner office with the view of the river.
He didn't want prestige anymore.
He wanted to be home in time to help Maddie with her homework. He wanted to be the one who showed up to the school play instead of missing it for a deposition in Chicago.
So he became, quietly, nobody. And he liked it that way.
Until Roland Vance decided to build a 12-story luxury condo complex directly on top of the small apartment building where Daniel and Maddie had lived for the last 3 years, and to do it by any means necessary, including a shell company designed specifically to push out tenants who couldn't afford lawyers.
Daniel could afford a lawyer. He was one. He just hadn't planned on ever having to be one again.
The first sign of trouble came in the form of a letter. Vance Development Group, LLC, was terminating all residential leases in the building effective in 60 days, citing a clause about structural renovation that Daniel recognized immediately as boilerplate nonsense, dressed up to look legal enough that most tenants wouldn't question it.
Most of his neighbors didn't.
An elderly woman named Ruth Okafor, who had lived in the building for 11 years and paid her rent on the first of every month without fail, cried in the hallway when she got her letter. A young couple with a newborn started packing before the ink on their letter had even dried, too frightened to fight back. Daniel read his letter twice, put it in a drawer, and went to a hearing to try to stop it the honest way by representing himself and the other tenants pro bono, filing an emergency injunction request in small claims court before it escalated further. That was the case that landed him in front of Judge Harmon Cole. Judge Cole had a reputation. Attorneys who appeared in his courtroom regularly knew to keep their heads down, speak only when addressed, and never, under any circumstances, challenge his rulings, because Cole had a habit of taking that personally. He golfed with developers. He had dinner with city council members. And he clearly recognized, the moment Roland Vance's name appeared on the docket, exactly which side of this case he intended to favor.
Mr.
Ellis, is it? Judge Cole had said on the first day, glancing at Daniel's filing with visible disdain.
And you're representing yourself and 11 other tenants, pro se? Do you have any legal background at all, or is this just enthusiasm?
I have some experience with contract law, Your Honor, Daniel said simply.
Some experience.
Cole repeated the phrase like it was a punchline.
Well,
we'll see how far some experience gets you against Ms. Deschmuck's firm. Priya Deschmuck, for her part, treated Daniel the way a shark treats a minnow, with barely concealed indifference, more interested in performing for the judge than actually engaging with Daniel's arguments. She filed motions designed to bury him in paperwork. She requested continuances specifically on days she knew Daniel had to pick Maddie up from school, forcing him to arrange emergency childcare or ask the court for delays that Judge Cole granted with visible irritation, muttering something about people who can't manage their own schedules. Roland Vance never spoke to Daniel directly.
He didn't need to.
He communicated through smirks across the courtroom, through comments made just loud enough for Daniel to hear as he walked past.
Cute little operation you've got going, Vance said once, adjusting his cufflinks. Real David and Goliath stuff. Except Goliath actually had a shot. Daniel said nothing. He took notes.
He built his case, evening after evening, after Maddie went to sleep, at the kitchen table under a lamp that flickered when the wind blew outside. The gut punch moment came 3 weeks into the proceedings, when Ruth Okafor, the elderly tenant who had done nothing but pay her rent faithfully for over a decade, was called to testify about the conditions in the building and the sudden lease termination. Ruth was nervous. She had never been in a courtroom before. Her hands shook slightly as she took the oath, and when Priya Deschmuck began cross-examining her, twisting her simple, honest answers into something that sounded evasive and confused, Judge Cole didn't intervene. He didn't ask Deschmuck to slow down or rephrase for a woman clearly overwhelmed by legal jargon. Instead, he sighed loudly and said, "Let's move this along, Ms. Okafor, we don't have all day."
Ruth's eyes welled up.
She looked over at Daniel, silently, the way someone looks at the only person in a room who seems to actually see them.
Daniel stood immediately. Your Honor, may I request a brief recess for my client? Your client, Cole repeated, amused. Right. Of course. He glanced at his watch. 5 minutes, Mr. Ellis. Try not to coach her too much.
The insinuation that Daniel might be feeding Ruth answers, that her confusion was somehow staged, landed like a slap.
Daniel walked Ruth to the hallway, got her a cup of water with shaking hands of his own, and told her quietly, "You didn't do anything wrong in there. None of this is your fault."
"I just don't understand why he talks to you like that," Ruth said, wiping her eyes.
You're the only one trying to help any of us. Daniel didn't answer that.
He couldn't, not without opening a door he wasn't ready to open yet. But something in him had shifted. Watching Ruth Okafor get humiliated for the crime of being old, poor, and unfamiliar with legal process that had cut deeper than anything Cole or Deschmuck had said directly to him. Over the following days, there were small clues, if anyone had been paying attention. A court clerk named Wesley, who filed paperwork in the building, noticed that Daniel's legal citations were formatted with a precision most self-represented litigants never bothered with. He mentioned it once, offhand, to a colleague, that Ellis guy writes briefs like somebody who's done this before.
A lot.
Once, when Deschmuck tried to slip in an inadmissible piece of evidence, Daniel objected using the exact statute number from memory, without needing to look it up, a level of recall that made even Deschmuck pause for half a second before recovering her composure. And once, in a rare unguarded moment in the hallway, an older attorney waiting for a different case glanced at Daniel's face and frowned, like he was trying to place him. "You look familiar," the man said.
You ever practice up in the city? Corporate side?
A long time ago, Daniel said, and left it at that. None of these moments registered with Judge Cole, who had already decided, the moment he saw Daniel's jacket and heard the phrase pro se, exactly what kind of man he was dealing with.
Cole wasn't interested in evidence.
He was interested in optics, and Daniel Ellis looked, to him, like exactly the kind of person a courtroom was allowed to dismiss.
That was Cole's mistake.
Not underestimating Daniel's intelligence, plenty of judges had made that error before and lived to regret it in private.
Cole's real mistake was doing it publicly, on the record, in a courtroom with an audio recording system, in front of witnesses, while making comments that veered well past stern judge territory and straight into misconduct. The turning point came on the sixth day of hearings, during closing arguments. Judge Cole had spent the morning making his usual comments, dismissing Daniel's filings as amateur hour, suggesting at one point that Daniel should leave the real lawyering to Ms. Deschmuck, and openly rolling his eyes when Daniel raised a valid procedural objection about the shell company's ownership structure. Your Honor,
Daniel said, standing calmly, I'd like to move to introduce Exhibit 14, the full corporate registration history of Vance Development Group's shell entity, obtained through a formal records request.
Do we really need another exhibit, Mr. Ellis?
Cole said, checking his watch again. At this rate we'll be here till Christmas. It's relevant to fraudulent conveyance, Your Honor, under section. I know what fraudulent conveyance is, Mr. Ellis, Cole snapped, irritation finally breaking through his condescension. I don't need a paralegal explaining basic law to me.
The room went quiet.
Daniel paused, and for the first time in 6 days, something in his posture changed.
He straightened. His voice, when it came, was still calm, but it had a different weight to it now, the kind of weight that came from a man who had spent 11 years in rooms far more hostile than this one.
With respect, Your Honor, I'm not a paralegal. I'm the former lead litigation partner at Griggs, Hale & Ellis, and I've argued 4 cases in front of the Second Circuit Court of Appeals. I recognize a fraudulent conveyance scheme when I see one, because I've spent a career prosecuting them for clients with a great deal more money than Mr. Vance.
The silence that followed was total.
Priya Deshmukh's confident expression cracked, just slightly, a flicker of recognition passing across her face.
Wait, she said quietly, almost to herself. Ellis. Daniel Ellis. Oh my God. Roland Vance sat forward.
That can't be the same. It is, Deshmukh said, staring at Daniel now like she was seeing him for the first time. I did a case study on one of his appeals in law school. Ellis versus Meridian Capital. She stopped herself, looking suddenly, deeply uncomfortable. Judge Cole's smile had vanished entirely. That's an interesting claim, Mr. Ellis, but this court requires documentation, not Exhibit 15, Your Honor, Daniel said, sliding a folder across the table. My bar admission records, my former firm's letterhead, and, for what it's worth, the transcript from Ellis versus Meridian Capital, in which the Second Circuit ruled 7-0 in my client's favor on precisely the kind of shell company fraud we're discussing today. The color had drained from Cole's face. He flipped through the documents with visibly shaking hands, the same hands that, 6 days earlier, had waved dismissively at Daniel's thrift-store jacket. This changes nothing about the court's authority that Cole started, but his voice had lost its certainty.
No, Daniel agreed quietly. It doesn't change the law, Your Honor. The law was always on my client's side. What it changes is that everyone in this room now understands I knew that from day one, and that every dismissive comment made about my competence, my clothing, or my client's understanding of these proceedings has been on the record the entire time. He gestured, briefly, toward the small red light on the court reporter's equipment. All of it. What happened over the next several days moved quickly, the way these things sometimes did once the truth finally broke the surface. Daniel's motion on the shell company was granted in full. The lease terminations were declared invalid, the eviction proceedings halted, and Vance Development Group was ordered to cover the tenants' legal costs and remain liable for the original lease terms for the full duration of their contracts. Roland Vance's confident smirk did not survive the ruling. He left the courtroom that day trying to talk over his own attorney, demanding an appeal, insisting this wasn't over, but the fraudulent conveyance evidence was airtight,
and everyone in the legal community who heard about the case knew exactly how it would end. Vance's company faced a formal investigation into the shell entity's registration, and 2 other tenant associations in unrelated buildings came forward with strikingly similar complaints once the story became public. Priya Deshmukh, to her credit, did something Daniel hadn't expected. She asked to speak with him privately after the final hearing. "I want to apologize," she said, without excuses attached to it. "I treated you like an obstacle instead of an opponent, because I judged you the same way the judge did. That was wrong of me, professionally and personally, and I'm sorry." Daniel studied her for a moment. He remembered being young in this profession too, remembered how easy it was to let ambition sand down the edges of basic decency. "You were doing your job the way it was taught to you," he said finally. "The question is what you do differently, going forward." It wasn't forgiveness, exactly. But it wasn't punishment either. It was something closer to a door left open. Judge Harmon Cole did not get the same grace, because Cole's behavior hadn't been a mistake born of youth or bad training, it had been a pattern, built over years of assuming that power and appearances were the same thing as justice. Daniel's formal complaint to the State Bar Disciplinary Committee, combined with the full audio transcript of 6 days' worth of comments, led to a suspension pending review, and a public censure that made the local paper. Daniel didn't celebrate that part. When a reporter asked him how it felt to see Judge Cole disciplined, Daniel just said, "I didn't do this to feel something about Judge Cole. I did it because Ruth Okafor deserved a courtroom that saw her as a person, not an inconvenience." That's all any of this was ever about. Ruth herself, for her part, kept her apartment, kept her home of 11 years, and started bringing Daniel and Maddie a plate of jollof rice every other Sunday, just because, she said, somebody ought to feed the man who fights for people nobody else bothers fighting for. Daniel didn't go back to corporate law. He didn't take the calls from 3 different firms that reached out within a week of the story breaking, offering him partnerships, corner offices, the kind of money that would have solved every financial worry he'd carried since his wife passed. Instead, he opened a small legal aid practice 2 blocks from Maddie's school. Simple sign out front. No marble lobby. Just a desk, a waiting room with mismatched chairs, and a policy of never turning away a tenant, a single parent, or an elderly person who needed someone in their corner and couldn't afford to pay for one. Maddie liked to sit in the waiting room some afternoons after school, doing her homework while her dad worked. Sometimes she'd ask him about the case, about the mean judge, about why people had been so unkind to him before they found out who he was. "It shouldn't have mattered who I was," Daniel told her one evening, packing up her backpack, the 2 of them getting ready to walk home together in the fading light. "It should have mattered what was true." People forget that sometimes, that the size of someone's paycheck isn't the size of their worth. Maddie thought about that for a second, the way 8-year-olds sometimes surprise you with how much they actually absorb. "So you're not gonna be a big fancy lawyer again?" she asked. Daniel smiled, took her hand, and they stepped out into the evening together. "No, sweetheart," he said. "I already am exactly the lawyer I want to be. I just had to remind a few people what that actually looks like. Sometimes the quietest man in the room isn't the weakest one, he's simply the one who chose, a long time ago, that his strength would be measured by who he protected, not by who was watching."